because I was very busy, is Cheryl Daniel is my mom and the law coach. When we talk about how we bring in other people, like when you're sitting down at mediation and they're trying to get to a resolution, sometimes if the lawyer thinks that we need somebody else, then we bring in Cheryl Daniel, who's a law coach who has a private practice in Point Pleasant Beach.
I think one of the things that Jay is saying that's important for me is that if the couple can work together, you save money, you work with your attorney, and there's a whole different process that goes on. What, Esther? Yes.
More than likely, the couples, I'm sure, ain't gonna hit it off. That's why we're getting a divorce.
Okay,
right?
and that's
Communication. So that's why I said that you can't just, that's why if a lawyer tries to fit you into a process, that may not work. You actually need to know the facts and circumstances of your case. It may be, like I said, I use a lot of the different processes together. Like you said, well, what happens if he doesn't want a divorce? Well, in that case, he's not going to sit down with you. You're not going to be able to negotiate. So in that case, when I get a chance to talk about litigation, in that case, then you're going to have to file and then you would default him, and we can talk about it more. And like you said, I can't sit across from the table. And another thing, people that are involved in domestic violence, mediation is not for you either. I talk about in my other seminars is the weighing of also people who have a control issue. Maybe one person's passive, one person's controlling. In that situation, mediation may not be for you. So maybe try a little bit of mediation, then try a little bit of a law coach. Then if it's not working, you may have to file. So you have to be someone like, that's why we all work well together, because if we have to use a little bit of each process to get you there, that's what we do. We don't just get stuck in one process and then that's where your legal fees get done.
And it's to all of our benefit we can get through mediation, because you never know what kind of mood the judge is going to be in that day.
Many times when I work with a client or a couple, I will find out more about the couple and I'll go to an attorney and talk to them, and they might even speak then without any fee to my clients about that my clients are thinking about mediation. So sometimes I'll look, just like Jay said, there has to be a fit between your attorney, whether it's a mediator or whoever. My particular fit is that I like the attorney to be a mediator and work with the attorney on any of the snags that come up so that we can move it along faster, and that way it's more cost effective. So I can be in touch, you sign a release that I can talk to Jay, to Vince, to Esther, and be able to say, listen, this is where a snag is going to come up. And they go, okay, we can do this, this, this. And so I'm already educating my client about it. They go to one of the attorneys, they already know, and it cuts down on a lot of the emotional communication that Jay was talking about before. Because when Jay was talking about, yeah, we can sit there and there can be lots of arguments, but you're paying for that and you're not getting anywhere. So you walk out of a meeting, you're all upset, and you learn very little, if anything. Now you got to come back and do this all over again. So that's why what we're doing tonight is to educate you so that you are beginning to know what is it that you need. And that's what we ask you, what is it that you need? So we'll tailor it. And we're definitely seasoned professionals. We know people pretty well and what their needs are. However, then you say, oh yes, this, that. And then you know whether you need a mediator or you want collaborative law.
Oh no, litigation, we have to go to court. But as Vince has said, sometimes we gotta get the wheels going. Mediation sounds wonderful. Let's sit down, let's be mushy, let's get it solved. That's great if you have a law coach normally. Sometimes people have the unequal bargaining power. Sometimes someone has more control over the other person. And when you sit down at mediation, there are certain attorneys that may not bring in a law coach or someone to equalize that level of communication between the parties. So when people say, oh no, litigation, sometimes litigation is a tool in the process. my colleagues will agree that yes, the best way to go is to sit down, let's do this nice, let's do what's best for the children, let's do what's best for the family. But sometimes you don't have two people that can do that. Some people, no matter how hard you try, you don't have a law coach that's even going to be able to make that happen. And in those cases, so that we save money, because mediation is less expensive if you can communicate. However, we have all had mediation cases where we had the buried attorney on the other side. So every time you set up a mediation, you try to get 4 people in the collaborative law process to sit down. And you can't get everybody into a room at the same time. So sometimes it takes a little bit longer. Sometimes you sit down and you just had a fight because it was a holiday and he didn't bring the child back on time. He never brought the child, or she didn't bring the child, or he didn't give me money, or she shut off the heat. I had someone, we ran out of oil, now the water shut off. So all those things are very difficult in a mediation or collaborative process. So what I like to do is in litigation, I gave you a handout. It's separate from our PowerPoint because I use this in a different seminar. Litigation talks about that both parties, just like collaborative law, both parties are going to have an attorney, both parties are going to get legal advice, and both parties can bring in any other professional, just like collaborative law. You can bring in mental health professionals, financial professionals, lending specialists. Like I had said earlier, that we have Sean O'Donnell here. Sometimes you need, all right, my car is owned by me, titled in my name, but we have a joint insurance. So now that we're going to live separate and apart, we need to get new automobile insurance. We also need to see what we're going to do with our investments, which we're going to talk about later. Now with litigation, you don't just show up in court and start arguing. You don't show up in court and start going before the judge. It's a process just like the mediation process. But in the litigation process, that's why you have to fit into the right method here. In the litigation process, there's deadlines. So if you're in a mediation situation where no one can get their dates together, you have one mediation and then 3 months later you have another mediation and you're like, what did we say in the last mediation? In litigation, you file for a complaint for divorce and you get deadlines. The court puts you on track. The first thing says about the file dates. You file your complaint for divorce. It goes to the court. It gets stamp marked filed. It comes back. Within 10 days, you serve the other party. This is where I say we mix litigation with mediation. Because years ago, you said, aha, I'm going to hire that process server and jam it right up. No. You don't have to do that anymore. You say, listen, does the other person know? Are you really going to? Do they know you're going to get a divorce? In that case, if you know that they're going to sign an acknowledgement that they got the complaint, you can send it certified and regular. I've had clients that actually handed it to their spouse and said, here, sign that you got this. When they sign that they got the complaint, the clock starts ticking. At that point, that person has 35 days to respond. In that 35-day period, they respond to the complaint. Normally, what most people do is irreconcilable differences. The attorney that says, I'm going to bury him or whatever, most likely that attorney might submit like a 20-page complaint about, in 1962, you left the light on. Those complaints are gone, all right? It's not important anymore. We're in the state of New Jersey. If one person was horrible and brutal to the other person, has a girlfriend, doesn't have a boyfriend, whatever it is, you're not going to get more money unless you go to trial. Even in litigation, it doesn't necessarily mean that your case is going to end up in trial. If you pick the right attorney and you file the complaint, once you file the complaint, they do an answer. You do something called a case information statement. The case information statement is pink in your packet. Most mediators fill out a case information statement. When you go to collaborative law, you fill out a case information statement normally, because your case information statement is going to tell you what your assets and your liabilities are between the parties. Sometimes someone forgot something. They forgot to put on there that they have $300,000 in a 401k. Now, maybe they really did forget it, but both parties fill it out and they say, I think my wife has this or my husband has that. So you use the case information statement to determine, all right, this is where we're starting. How are we going to distribute it? Because I always say that when you're married, You take the good with the bad. So what that means is normally when you're married, from the date of your marriage to the date that you file for a complaint or the date that you decide you're going to equitably distribute your property, whether the house is in your name, doesn't matter. If you bought it during the marriage, it's joint. If you have a credit card, both parties used it, it's joint. I had one person say, I bought Wawa, but he bought Wawa coffee every day. I didn't drink it. I said, guess what, you have to pay.
But I'm talking totally separate. He never
Doesn't
touched
matter.
one of my accounts. And I mean, because I never, if he couldn't use my credit card, he wasn't an authorized user, or my bank account.
Management conference. Attached to that handout, it's like a buff color that says case management order. Now, if you're in Monmouth County, the parties do not have to appear for a case management conference because you can submit the pink sheet, which is your case information statement, and the parties can fill out this case management order and send it into the court, and there's no appearance required. In Ocean County, there are certain judges that will allow you to consent to a case management order, fill it out, and send it in. It's just got to be in before your court date. Now, again, you don't have to be nervous about your case management order, case management conference date. All this order says is we're going to start moving you forward. What kind of a case are you on? Is this something with a lot of assets where it's going to be a complex track? Do we have a business? When we say complex track, is the case management order determines your discovery period. You know, we talk about full disclosure. So during the discovery period, there's questions that are sent to each party, which are interrogatories. Sometimes, if you're gonna buy the other party out of your marital residence, you're gonna have to do an appraisal of your house. If you're not gonna buy it, then most parties will just agree upon an appraisal and the house gets listed for sale. But if you look at the second page of this, down at the bottom, it talks about when are we gonna get the real estate appraisals? When are we gonna get the personality appraisals? When are we gonna get the business appraisals? And when are we gonna get the pension appraisals? So you submit this to the court and you're on track. This is when all these things need to get done. When you sit down in mediation or collaborative law, usually at your first meeting, you can say, this is when we're going to get these things done. So when we say, the reason why we wanted to tell you about your options is because all these options are very similar. It just depends on which one's best for you. Here you have a judge telling you, in mediation, can you trust the other party to stay on track? Can you trust that when we say we're going to get your pension appraised, is he going to do it then? Is the other party going to follow through? And that's with having the right attorney. You know that attorneys that work together will stay on track in mediation, and you don't need, my mother calls it Big Papa watching you. Big Papa's the judge. So if you don't do these deadlines, the judge says, what are you doing? Why didn't you do this?
Which I just want to mention that in some cases that I've had, we've really needed Big Papa because the court and the judge, you should never be afraid of litigation if you really have to do it, because sometimes your spouse will not be cooperative. And like Jay said, the attorneys are very skilled at trying very hard to get the couple to be cooperative. But once in a while, I'll get a client, it's not going to happen. And then I look to litigation, as my daughter and I are talking about it, as you will fill this out. If your attorney is on board, so if Jay's on board with Esther, they know, hey, this has got to be done in this time frame, and if that guy doesn't do it, what happens?